There's various key dates, as I see it. 1992 was a key date when there was the last ever criminal trial of high-level bankers from the City of London, which was the Blue Arrow trial. 3 senior executives of a bank called County NatWest were given suspended sentences for rigging a rights issue. And one stockbroker who helped them from UBS Phillips & Drew was also given a suspended sentence for rigging a rights issue. Now, the trouble was, this didn't go down particularly well with the establishment, so they engineered a Court of Appeal case in July 92 where the sentences were quashed. And on the day of the quashing of the sentences, a friend of mine was phoned by a contact of his in the SFO, Serious Fraud Office, and the contact in the Serious Fraud Office basically said, the message has come down from on high. There will never again be a prosecution of a high-level banker or a mainstream city institution. So it would appear that from that moment on, there was a kind of new agenda had been set whereby people in the city, and bankers in particular, were given carte blanche to do as they chose. This could include false accounting, defrauding their clients, could include money laundering. And it seems that a dangerous precedent was set at that moment. But the situation, if anything, got worse under Tony Blair and Gordon Brown, when in 2000 they passed an act called the Financial Services and Markets Act 2000, which included a clause which said that the competitiveness of the city was more important than the rule of law. It said that regulators must consider the international mobility of the financial businesses before taking enforcement action, and they must avoid damaging the UK's competitiveness. So essentially, they were telling the FSA, the newly born FSA, that it should always consider whether or not financial institutions might move overseas before they prosecuted them.